Good morning.
Please, yes, please introduce yourself without mentioning your name.
Uh, I passed BLLB honors from University Law College, Gandhi Bihar in the year 2016 to 2021 batch. Then I completed my LLM in the year 2022 in Constitutional Administrative Law specialization from Kids School of Law. Then in the same year I cleared UGC Net Law, and I belong to Bhubaneswar only, but my native is Pune.
Sir,
Ole, what are you presently doing?
Presently, I am acting as a guest faculty in University Law College, Malaysia.
In what subject you are teaching there? What
Uh,
subject of law you are teaching
sorry, I'm just.
there?
Uh,
Okay,
I'm teaching constitutional law, then law of torts. Two subjects presently I'm teaching.
okay. What is basic structure doctrine which has been laid down by the Honorable Supreme Court?
Basic structure doctrine has been laid down for the very first time in the case of Keshan and Bharti versus state of Kerala in the year of 1973, which talked about the amendment procedure to the constitution, which can change every part of the constitution until and unless it hampers the basic structure. And the concept of basic structure is something like this: it has not yet defined, but there are some concepts like equality before law, equal protection of law, law of secularism, which the principles which are enshrined in the Indian Constitution's preamble and also in the Constitution. So the judiciary is yet to decide time and again what is the basic structure, and if any law, bylaw, notification, order of any legislative wing or executive, if it hampers, then it can be struck down by the exercise of judicial review, judicial activism, or any other power.
Why it is called as basic structure? Name is like basic structure.
Basic structure because it is all about the skeleton of the constitution and what our objective resolution was about, what the entire purpose and the constitutional law of our nation is about to secure. All those
Whether
principles.
judicial whether judicial review is a basic structure of the constitution.
Judicial review is there to control whether basic structure is getting hampered or not. So I think so. Judicial review is a part of independence of judiciary, and independence of judiciary is a salient feature of the Indian Constitution. So by that logic, if we say, then I think judicial review is also a basic structure.
Are you aware of this mineral mill case?
Yes, sir.
Can you say what has been decided there apart from Goloknath
Mineral
case?
Mills case has given lights over two concepts. Like first is on secularism, then is on judicial review, and whether preamble is a part of the Indian Constitution or not. Finally, it has been decided that preamble is a part of the Indian Constitution because it is all about being the preface of the Indian Constitution and the principles, and anything which is hampering the basic structure that can be struck down.
If tort has been defined in any other any statute in Indian law, in Indian statute,
Yes, sir. Yeah. In general, tort is not codified, but in Section 2M of Limitation Act of 1963, tort has been defined that it is a civil wrong which is not exclusively a breach of contract or breach of trust.
okay. So what is the difference between robbery and extortion?
Uh, Robbery is basically an aggravated form of extortion and theft. So, robbery includes both theft and extortion. So, when extortion exactly talks about the showing of fear or injury in order to deliver some property, and when it is on spot, and the fear of injury is also on spot, then it can become robbery.
Yes. Is there any provision in the CRPC where there is a female who has been abducted and been detained? Is there any
Yes,
provision in the CRPC for
yes, yes.
restoration of that female?
Yes, sir. It is in section 98 of CRPC, which talks about the females of minor or above that. If they are adopted by any person, then they can be um, released by the police or by any action through search warrants.
Whether for such abduction can there be read by the Honorable High Court?
Uh, yes, sir. Actually, if you can link a writ, that is writ of habeas corpus, which talks about unlawful detention. And 97 of CRPC also talks about this unlawful detention, but specifically 98 talks about abduction of females. So
Then
writ
what
of
is the difference between section 97 CRPC and the writ of habeas corpus?
uh, section 97 is especially criminal in nature because it is mentioned in CRPC. And so writ of habeas corpus can be, it is having a more ambit, we can say.
Yes, okay. What is an inchoate crime?
Inchoate crime means it is not exactly the offense, or it does not, it does not constitute the offense as whole. Rather, it contributes to the commission of offense. So, as we say, there are different stages of crime like intention, preparation, attempt, and commission. Then I think so. Inchoate crimes come in between the intention and commission. It is either preparation or attempt. So, some inchoate crimes example I can give like abatement of any offense, criminal conspiracy of any offense.
Inchoate crime is not itself punishable.
It is punishable, but it is not exactly an offense. We can tell because they give rise to an offense or they aid to an offense.
What is offense?
Offense is defined two ways. One in CRPC, that is section 2N, and one is section 14 IPC, where offense means any wrong or any crime which is punishable by the law in force. And according to section 2M of CRPC, any section 20 of Cattle Trespass Act also talks about offense.
What is cattle trespass?
Uh,
Have you any idea?
no, I have no idea, but I have just read about it.
Simply you have remembered this is a cattle trespass.
Cattle Trespass section 20. I will go through it actually.
What is lease?
Lease is the transfer of interest in specific immovable property, which only talks about transfer of enjoyment. And there can be types of leases like leases from year to year, permanent leases, and less than year one leases.
What is license?
Um, License, sir, I'm not that into that. So,
You are not aware. Okay.
sir, I'm aware, but I cannot define in terms. I will go through.
Okay. Can you distinguish what is lease and what is license?
Sorry, sir. That I will go through. That topic is.
Whether the provisions, this chapter of gift is applicable to Mohammedan gifts?
So, can you repeat?
Whether the provisions of gift chapter, whether that is applicable to gift made by a Mohammedan?
No, sir. Actually, the chapter 7 of Transfer of Property Act is not applicable to Muslims. It has been given in 129 perhaps of TP Act, where the mortis causa concept and it is not applicable to Muslims. It has also been given.
Can you say what is gift?
Uh, Gift is transfer of interest of a property, whether movable or immovable, to a person without any consideration, and that property can be existing can be future also. So it is basically a gratuitous transfer.
What is mortgage?
Mortgage is defined in Section 58 of Transfer of Property Act 1882, which defines like this: the transfer of interest in specific immovable property, which secures three things. One is the payment, whether it is advanced or which is to be advanced, or whether it is existing or about future debt, or performance of an engagement which gives rise to a pecuniary liability. So it's especially something when a immovable property is given to some person in lieu of some money. So the person who gives the property, he is the mortgager, and to whom it is given, he is a mortgagee, and the amount considered is mortgage money, and the deed involved is mortgage deed. So there are different types of mortgages: simple mortgage, mortgage by conditional
Okay.
sale, etc.
Is there any particular mortgage where no even writing of a document is required?
Where writing of?
Any document is not required. Writing is
Yes,
not required.
sir. That is, I think, mortgage by deposit of title deeds.
Where that is to know?
Section I cannot remember, but only by giving title deeds, I
But
think that
I
can
don't
be
know
done.
what section. Okay. Okay. What is summons? In the
So,
as per the
sorry.
what is summons under the civil
Summons.
procedure?
Okay. Sir, summons is actually the authoritative call by the court to a person to present in the court, either as a witness or as a party, to give a glimpse about about the cases or the suit, whatever.
When the court will order for substituted service of summons,
Substituted service of summons means when the person who is called to the court is not available, then substituted service of summons can be given, and that's so that the summons can be fixed in any conspicuous part of the court hall, or any place where the person is residing, or any village where the person is residing, or in the daily newspaper also that can be published so as to make that person aware of the summons.
what is dying declaration?
Dying declaration is basically the statement given by a person regarding the cause and circumstances which led to his or her death. So that has been given in section 32(1) of Indian Evidence.
Why dying declaration is admissible in evidence, though it is a hearsay in nature?
A maxim will come into play, that is nemo meritoris mentally pro causa, which talks about that no person will say a lie before his death. So it gives effect to the substantive power of that dying declaration. And I think so. The right person is the person himself who will talk about the circumstances which led to his death.
What is estoppel?
Estoppel is to stop or bar from doing something. So estoppel, I can explain in terms of various examples. Estoppel by deed, estoppel by pass, estoppel by conduct, or pass is same. Estoppel by papers. So everything can be done if you have declared something in the past, then you cannot deny or retract from it in the future. So this is what
Can there
it
be an
is.
estoppel against law?
Estoppel against law.
Law.
Uh, Law as in, sir, which particular concept to it?
Any law. Suppose somebody erroneously accepted a law, legal position, and somebody unchanged his position. Can there be an estoppel against law?
So, estoppel, there can be an estoppel because according to section 115 of Indian Evidence Act, if something has been mentioned by a person in law, means in court of law, then they cannot bar or they cannot deny from it in the future.
What is the admission?
Uh, Admission is a statement or inference according to section 17 of the Indian Evidence Act, which talks about, which is given by the which is given by the person regarding to relevant fact or fact and issue, and That is all about admission. Actually, it is talking about the person which talks about the relevant fact and fact issue, or the circumstances which related to which are related to.
What is fact in issue?
Fact and issue, sir, entire definition will I say, as per section
No,
3.
what do you understand fact in issue? What do you
Fact
understand?
and issue is something, some, it is a thing when it is by itself, or something which is related to other, which is connected to the fact, to facts or relevant facts, or nature, extent, or any kind of existence, non-existence, which as a whole talks about the fact, or the facts which are in dispute or which are in issue.
So an admission of a third person is relevant.
Admission by third person is relevant in some cases, where the person is an expert, or where the uh, parties are the parties involved are not present, or dead, or cannot be found for some reason, or incapable of giving evidences. Then only third persons can be given. Third persons again can be divided into different categories. Like third persons belong to which they are either related to them, or they are experts, or the person is dead.
You are in a noble profession, that is a teaching profession. You have completed a LLM degree. Why you choose to come to a judicial, to be appointed as a judicial officer?
That is, of course, another noble profession. So, and actually, I want to be in a practical field where I can give my best, and I can try to ensure justice in the very grassroots level. And I am a very ardent follower of Gandhian principles. So, I believe it's something to be done. It is not only always in theories, rather, practicality can help it more.
You are a believer of Gandhian principle. What is the two rules of a Gandhi which will make a man happy? Always a person happy.
So, your voice is a bit slower.
Okay, you follow Gandhian principle? Yes.
Yes,
Can
no,
you
not an
say
ardent, but
possible
I believe those.
at least two principle of Gandhi which will make you happy?
So both the two very famous principles, truth and nonviolence, that everyone supports. I too, and also I feel that there are some principles of Gandhi which are incorporated in the Indian Constitution as well, like Article 40, which talks about organization of village panchayats. That is a very strong supporter of Gandhian principles. So if Constitution is supporting, I think so everyone should support.
Which principle of Gandhi will help you if you are a judicial officer?
Uh, Gandhi,
Make you a perfect judicial
MK
officer.
Gandhi have always supported the concept of grassroots democracy. So if we enter into judicial services, then if we see the people their challenges from the very lower level, and if we will try to solve it from the lower level itself, I think so it will not get in an aggravated form,
I
and it
will
will be
solve the
stopped.
problem of this. Where a dispute will come to you as a judicial officer, either a civil dispute or a criminal one. Criminal one. The offense has been committed.
Yes.
How it will solve in the grassroots level? You are
So
not
there are
supposed to
other
do any
concepts like
democratic work
gram
there.
manners, and presently I think so, sir, in ADR mechanism, some judicial officers are also appointed as in the mediators or gram manners persons. So there, I think Gandhian principle is more effective, where
What
people.
principle? What Gandhian principle? You are again unhappy on Gandhian principle. You follow Gandhian principle. What principles of Gandhi influence you more?
Also, communicating to people from the grassroots level, and
Only
everything should
communicating. Only communicating.
communicating and listening to them, and being very transparent. I think so that will be.
What do you mean by natural justice?
Natural justice is an intrinsic form of justice which talks about two principles. That is, one is audi alteram partem, where no party shall be left unharmed, and second is nemo judex in causa sua, where a person should not be a judge in his own case. So these two are the principles of natural justice. So everywhere, where even if procedural laws are followed or not, that's a different aspect. So natural justice should be prevailed.
What is law?
What is law? So law, according to Austin, I will directly tell the definition. It is the command of the sovereign backed by sanction,
How
followed
do
by
you
detention.
understand law? Definitions are there. According to
The law
what is law?
basically, sir,
I'm a
law is
layman. I
basically
put
the
a question. What is law?
So again, if I start again anthropologically, we were humans and we were very gregarious in nature. So we started to live in societies. That societies became states. The states were being ruled by some people. So in order to rule people or in order to serve people, to be very specific, some laws are required, which will make them a penalty or which will give them a penal fear, so that they will follow law and discipline and everything will be maintained in the society. So law is that.
Okay, thank you. I will give you feedback after this interview is over. Other panelists, I will give you the feedback
Yes, sir.
about your interview.
Thank you, sir. Suchi, please tell me uh, whether against a non-registration of FIR by a police, a PIL can be filed.
Non-registration of FIR. Uh, yes, yes, sir. Yeah, you can.
Okay. What is the evidentiary value of a case diary?
Uh, Case diary is actually it's a evidence which need to be corroborated by other evidences as well, and it is not a substantive piece of evidence. It is a corroborative piece.
Can I use it to contradict anyone?
Uh, it can be only done by the person who calls for it, by the person or the side of the victim of the prosecution. Rather, only the accused has a chance to contradict if the police officer, investigating officer, or the prosecution side allows them.
What do you understand by doctrine of harmonious construction?
Doctrine of harmonious construction is talking about the interpretation of statutes, where we need to interpret the laws taking into consideration the parametric operation, where every law and every aspect of society is being observed.
Okay, that Visakha guidelines are there for prevention of sexual harassment at workplace. Can you tell me violation of which fundamental right it talks about?
Um, it can be two fundamental rights to be very specific, and if you can aggregate three, third can also be there. The first is right to equality, first of all. Then is right to freedom. Also, the liberty of women are being curtailed. Then last one, if exploitation is increased, then right against exploitation can also be granted.
Freedom of what? Freedom of what? Liberty and freedom of what?
Freedom of speech and expression, to be very specific.
But their speech and expression is not curtailed in any way.
So actually, under Article 19, there are different, especially Article 19(1) G or H, which talks about freedom of having any trade, occupation, or business to propagate any of them according to their wish.
Right, right. Can there be an interrogatory between the co-defendants?
Uh, yes, it can be. Because in a case of Iftikhar Muhammad versus Sheikh Meherban Ali, if I am not wrong, their co-defendants and pro forma defendants had their own thing to bring the matter into suit.
What is the difference between section 205 CRPC and section 317 CRPC?
205 CRPC especially talks about the 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 avoidance of the personal attendance of the party before the cognizance, perhaps. But 317 talks about after in the inquiry and trial stage, where the personal attendance can be barred of a accused or of the parties.
What is the difference between a proclamation and a proclaimed offender?
Proclaimed offender is a person uh, who has absconded or who has uh, left the or left some place after committing any crime, which comes under different proclaimed offender offences like murder 302, 304, and etc. And proclamation is uh, summoning that person, summoning the proclaimed offender. Summoning has been summon, warrant, then proclamation, then attachment. Then this is the procedure. So just call the process is known as proclamation, and the offender is proclaimed. I think so. I will look into it.
Okay, okay. There is a there is a rule in CPC which is called D bene esse, D bene esse or D bene is rule. Can you tell me that? What does it talk about? D E
Mm,
B E N N E E S S E. D bene
yes,
esse. Not rule. Okay. Okay. What is a personal recognizance bond? PR bond?
PR bond. Personal recognizance bond is where a police can release a person after arresting in the from the police station itself.
Okay, only police can do that.
Uh, as per example is police can do it. Any person who is on the very first instance, if they are releasing the person, then that is a PR.
First instance as in?
First instance, I think just after arrest or just after custody, bringing into the custody.
Okay. Okay. Whether an evidence of a sniffer dog is a primary evidence or a secondary evidence? I mean,
There are two case laws regarding that. One is Abdul Razak versus state of UP, and another case is some South Indian case versus state of Andhra Pradesh versus Vijayawardhan or something, where it has been told that the sniffer dogs is a scientific evidence, so it is true. But further, it has been cancelled by the South Indian case, which talks about that the dog is being mastered by a person. So therefore, entirely we cannot rely upon the sniffer dog's evidence.
so what will it be? Whether it will be direct or hearsay?
Uh, Direct or hearsay, it cannot be. It can be a corroborative piece of evidence. It needs other evidences as well.
But you said that it is through a master. So whatever
Through a
the
master
master
means
interprets,
the person. That can be indirect. We can say hearsay.
whether you had personal law or law of contract, or
Personal.
constitution, personal law. What is Hadya?
Muslim law. So family law I need to revise, but I don't know about it.
Okay. Whether a Hindu boy and a Hindu girl can marry under Special Marriage Act.
Special Marriage Act especially talks about people from different religions getting married. So if Hindu boy and Hindu girl are getting married, Hindu Marriage Act is itself there. But I
But
think so there is no bar in.
they don't want to get married under Hindu Marriage Act. They say, "Ah, we want to get married under Special Marriage Act."
I think they can.
Okay. Uh, uh, can you tell me what is the difference between Section 5 of Limitation Act and Section 6 of Limitation Act? What is the prime difference if you want to differentiate?
Section 5 and 6. Mm. Section 6 of Limitation Act talks about the disability ceasing of the parties, where a disability comes into force. Then, after the disability gets ceased, then the fresh period of limitation begins. And I think so Section 5 talks about when the court is closed, then the reopening day will be considered. Sorry, Section 5 is condonation of delay. Right? Condonation of delay. Yeah. If a solid reason is given, then if a strong reason is given, then the limitation period can be extended.
But what is the difference? I mean, okay,
Difference is
to be
the point of
specific,
disability.
yes, to which cases it is applicable to?
This is applicable to especially point of disability, and this
No,
is applicable to.
which kind of cases, I mean, whether suits, appeals, executions.
Okay, okay. Likewise. Okay. This is applicable to suit and this is applicable to suit and execution applications, and the other one is applicable to appeals and applications.
Okay, can you name me a few social welfare legislations
Social welfare legislations regarding.
regarding anything, regarding the betterment of people, the betterment of any class of
Actually,
people?
if we see our Indian Constitution, DPSP have different wings. Social welfare wing is there. So from that, if we see, uh, first is this Legal Service Authority, Legal Services Act, which talks national NLSA, and State Legal Service Authority, which talks about free legal aid. And another act is there's Protection of Women from Domestic Violence Act. Then there are various acts. There is Prohibition of Dowry, the Dowry Prohibition Act, etc.
But they are imposing penalties. They are not doing any welfare. They are imposing penalties.
Welfare of the other section of the people. No? But to be very specific, if social welfare is the issue, then I think it's a Free Legal Aid Act, that NLSA Act will come into force. And NHRC provisions, NHRC Act, Human Rights Act will also be a social welfare.
Since you mentioned PWDV, whether a male person can be a person who is an aggrieved person under PWDV Act.
It's only a female who is to be agreed on it. Protection of women from women is the very important.
Okay. Yes. Please tell me what is a jail appeal?
Jail appeal is an appeal which is taken by a UTP, under trial prisoner, or a person who is in custody.
What is a Mareva injunction?
No idea, sir. Okay.
Okay, my last question is that yes, you said that you wanted to impact the society directly going to a practical field. I don't see any better way to do it than being a teacher. I mean, I personally tell you, if you come to judiciary, you will restrain yourself and not be able to directly impact in any manner. You'll be just dealing with your cases. So justify me, why is this inclination for judiciary when your aim is to directly impact?
Uh, Directly impact can be again divided into two categories. Whether you are teaching people, that is a theoretical part of it, and we are when we were giving judgments or decrees, that is actually having more impact and power over people. So it is something, teaching is a secondary part of it. It is not exactly what we need, what we want to confer, that will be conferred upon them. So I think so. Being a judicial officer, the grassroots democracy or the grassroots justice can be maintained. So I'm more inclined to judicial.
What is your view of Indian economy at the present?
Indian economy at the present. Uh, Although the GDP is not decreasing, but there are some sham transactions which is happening in this present. I'm not giving a negative view, but I can say the economy can be strengthened by some other methods, like CRR, LLR, SLR can be increased, and the some other sources of income can be increased. Like some people say the housewives are not considered as a part of the GDP. So if I can add to it that if the housewife is saving the money of a maid, if the housewife is saving the money of a cook, if the housewife is saving the money of a help, and if the housewife is doing a lot of things for other people to work, so that they can earn money for home. And that can be a part of GDP as well. That is just my point of view. And this, some other sham transactions like in India, there are various other economic opportunities which can be strengthened instead of making a lot of temples, instead of making a lot of constructions which is not required at this present time. So I think so that will eradicate poverty. This will not eradicate poverty. So in order to become economic hit in the global arena, proper economists are required in the economic field.
Yeah, last question. Essentially, because you mentioned CRR and LR, can you tell me what is the difference between repo rate and reverse repo rate?
Repo rate is the interest rate which RBI takes from other commercial banks when they have to keep some money with RBI. But in the case of reverse rate,
Keep some money with RBI.
uh, when RBI, when the commercial bank they keep their ratio with they keep their reserve ratio some reserves with RBI, then the amount of interest which RBI takes from them, that is repo rate, and the reverse wala, that is with the commercial banks take their interest from RBI, that is known as reverse repo rate.
Okay. Okay. Thank you. We can proceed to the feedback. Over to you, sir, for the feedback.
Okay. Shruti, your name is Sucharita.
Suchintita.
Suchintita. Suchintita.
Yes.
Your performance is well because you are in service. You are in teacher service or a lecture service. More question may come to you from your job on the point of the teaching which you are giving, that is constitution and taught. You are always expected. First thing, when you are giving your answer must not be lengthy. Lengthy answer sometimes attracts problem for you, brings problem for you. So
Yes.
as much of the what I want, because it is simply a personality test. In a personality test, you should share. My question was, what is basic structure? You are aware? Basic structure means, suppose there is a house, some pillars, this plinth, those are basic structures. If one of the pillar is removed, then that house will demolish. So you should know that is why basic structure of the question. So basic structure, if a particular matter is amended, it is removed, then the entire constitution will demolish. By another Minerva Mill case, judicial review is one of the basic structure that has been decided there. First, you should have clarity. This is basic structure. There is a house, pillars are there, and if one pillar is removed, can the house stand? Similarly, if a constitution has a basic structure like secularism, parliament form of government, if any of the structure is removed, that the constitution will be demolished. So now you should have a clarity of that. What is tort? You define tort is a civil law other than breach of contract, breach of trust, remedies, unliquidated damages. Suffice this much. Yes, I put a question to you. I questioned you whether it has been defined. Yes, the definition is there. That you can define. If it is remember, if you are unable to recollect your memory regarding this section, never say. The examiner is not asking, or the interviewer is not asking you to know the section, to know the concept. Because it is a personality test. Your knowledge has been tested in the main written examination. Then abduction of restoration. Abduction you also do. What is robbery? Robbery, extortion. Therefore, I put a question. A theft becomes robbery and extortion becomes robbery in a particular circumstance. While committing theft, an injury is caused to the victim, or while committing extortion, if then and there any threat is caused to cause death, grievous or extent, and that is robbery. You are aware of it, extortion and robbery. Then, writ of habeas corpus, is there. The difference is that in section 97, the detention emotion offense, there is a confinement. Only in such case the magistrate issue such warrant. But High Court's power is very wide power, any detention, any type of detention. That is the difference. In search warrant, 97 and DT of habeas corpus. In DT of habeas corpus, any details. That kind. Then, in court crime, you say in court crime is not. Yes, in court crime is also punishable. Suppose somebody, there is preparation for committing the crime. In court crime has not been completed, an act has not been completed, but in certain cases that is in court crime. Simply abetting is also, that is also punishable. Even assemble for the purpose of committing docility, that is all punishable. So your concept must be. Never be, that is sometimes what happens, if you give more sentences, you give or going, that is, give lectures, that sometimes attracts problem, brings problem. And offense you also correctly define. Cattle trespass means what? Cattle trespass, this is India is a agriculture oriented. Previously, only agriculture was the main source of it. So that is why during British time, the cattle, if enter somebody's land, that is agricultural and damages, that has been treated as an offense. So that is called cattle trespass. Cattle trespass, damaging crop of somebody. So for us, we transfer, I think, some basic, some clarity is not there. Always, we get a transfer of right, never an interest. Always remember, the mortgage and the sell.
Yes, sir, actually wrongly mentioned. Transfer of enjoyment rights. So, then I realized.
Transfer of right to enjoy property.
Yes,
Right
yes,
to enjoy property a certain period. 3 things. Leave a payment of rent or period. License means any entry to a particular land of another, permission to enter into the land of another. Without such permission, the entry is illegal. No right is not. Only simply a permission has been given to somebody. Suppose a meter reader comes to your house to take the reading of your meter. He comes, enters there as a licensee. Already an implied permission has been given. When you enter into a cinema hall, there you enter as a licensee. No right is there. Gift. Gift is a voluntary transfer of property without consideration. Existing property. That is very important. Made by a person called donor to the donee, and that must be accepted by the donee during the lifetime of the donor and still capable. These are required. And possession is also acceptance is equal. Probably you are clear. Now, your answer was gift is a transfer of interest, never transfer of ownership. Mortgage is a transfer of an interest, only a particular one single interest, as security for payment of this much. Transfer of an interest as security for payment. Equitable mortgage in Calcutta, Bombay, Madras, or in such of the places as notified by the government, a property by depositing title of the property a person can create. That is called equitable mortgage. Summons is a written. Summons is always issued in writing, in duplicate, signed by the presiding officer of the court or such as officer as authorized by the court with the seal of the court directing a person to remain to appear before the court. That's enough. Substituted service of summons. When the defendant is keeping him out of way or receiving summons or avoiding to receive summons, then only substituted summons will be issued. Only avoiding service of summons. As you know, by affixing a copy of that summons in the notice board and conspicuous part of the house where the defendant was residing, or in such other mode as the court thinks fit. Or in such other mode means that maybe by bit of drum, by publication in a newspaper. If court orders, the publication of a newspaper is not mandatory. But the court orders that publication is a newspaper, that must be in a local newspaper widely circulated in the place where the defendant was. So now you are substituted service. Dying declaration. Dying declaration is a statement given by a person regarding the cause of his death or any of the circumstances of the transaction leading to his death. That is admissible because that person is dead and his cause of death is in question. He is the best person to know what is the reason of it. Of course, dying declaration, that is a principle. A person, dead person, a person who is about to die will not expect, it is not expected that he will tell lie. Falsely implicate somebody regarding the cause of his death. Estoppel, I put a question. Estoppel is a declaration, act, omission. If by a person, by his act, declaration, omission, made another person to believe something to be true. And on that belief, that other person has acted upon. Then in a suit or proceeding, he cannot deny the truth of the same. It is a rule of evidence. Probably understood? Admission. Admission is a statement, either orally or in writing or electronic form. We suggest an inference. You omitted it. Suggest an inference regarding the fact in issue, relevant facts, and made by the person under the circumstances as mentioned in the Evidence Act. I put a question whether admission of a third person is relevant. Yes, whose position is to be proved as against a party to the suit. Admission of a person whose position, probably that's a very important question in the Evidence Act. Suppose the illustration will make you clear. X filed a suit for Y for not collecting rent due from Z. Z has said, yes, I am liable to give rent to X. So Z statement is an admission. Whose position is to, or the parties have referred specifically. Somebody has referred specifically. This statement is also somebody. Admission. Then Gandhian principle, I told you, you put unnecessary. Yes, Gandhian principle, it may be there. Two principles of Gandhi's, that is truth and independence and ahimsa. Non-violence, truth, independence, and minimum requirement in life. That is the Gandhian principle, make a person happy. Gandhi was never a materialistic person like us. Very minimum requirement. Only truth. If a judicial officer is truthful, if a person is truthful, no problem will come to him. Any problem may come for a time being, then that will disappear. So that is truth. Gandhi brought freedom for truth and non-violence. This is. Then I put a question why you are choosing or you are willing to, or your desire to be a judicial officer. Your answer will be very simple because it is a prestigious, secure, and independent job. This much. Never say grassroots officer, that is different thing. It is a prestigious, secure, and independent job. Because if you say many things, many problem will come to you. Lease and license. Lease is also, as I told you, yes, law. I put a question, what is law? Law, best definition is Salman. Law are the rules, they recognize the state in the administration of justice. That's all. Okay. Your performance is good. Be confident. Never make your answers lengthy. Try give harp on your subject because already your number has been, the knowledge has been tested in the written examination. Go with your confidence. Thank you.
Thank you, sir.
No.
Yes, Suchi, thank you, sir, for the detailed feedback. Yes, Suchi, I also agree with sir that only I think your conceptual clarity is there to much extent it is there. The only thing that can stop you from cracking this is only yourself. Why do I say so? Because you are giving lengthy answers and then inviting trouble, and sometimes you get impatient. You are not you just because you know it, you are so uh, because of course you know the things, but then you have to wait for the interview to finish the question and then take a pause and then reflect an answer. And in that way you will also ensure that only less questions can be put to you. Okay, because you are making it a rapid fire by answering very quickly. You are making it a rapid fire and again inviting trouble for yourself. So don't do that. You have time. They will give 30 minutes to you. So 30 minutes means you should try at least within 15, 20 minutes, 20 questions, it should be over. If you do it in this manner, then it will be inviting trouble for you. So don't do that. Yes, some questions that you could not answer, I will tell you. Yes, against the police non-resistant, can a PIL be entertained? No, a PIL cannot be entertained against a non-resistant FIR by police. Okay, and sexual harassment of workplace, yes, 191G. 191G, it is in violation of that. Case diary, the evidentiary value, yes, it is corroborative, it is not substantive, but contradiction we can use when the police uses it to refresh his memory. Then that part of case diary we can use to contradict him. Jail appeal are the appeals that are sent through the superintendent of jail, because the person who is in jail, he cannot approach the court directly. So what he can do is he can file a jail appeal. Mareva injunction, it is nothing but a restraint order of the court which freezes the defendant's assets when the defendant wants to dispose of them in order to defraud the plaintiff or in order to defraud the decree. So you freeze the assets of the plaintiff. Okay, so difference between section 205 and 319. 205 is for all times. Once it is allowed, it is for all times. But 317 only for single instance, only for that particular day it is allowed. Okay. And I asked PR bond. PR bond is not when you release him on first instance. That is when you release him on his own bond. You don't need a surety on my own bond. If you are releasing me, then only that's a PR bond. Okay, that can be at any stage, at instant stage, in the later stage, that is fine. But yes, it can be whether in his own bond or not. Yes, yes. Special Marriage Act, Hindu boy, Hindu girl, can they do it? Hindu boy with any other religion, that would have been attracting Special Marriage Act. But Hindu boy, Hindu girl, it should be Hindu Marriage Act. Okay. Then I- what else I asked? I asked D bine esse rule. D bine esse rule is when a witness is present, then he himself may ask that I may be examined first, because it is the need, because I am ill or I am going to out of country, so I may be examined first. So examining the witness first is called D bine esse rule. Okay, sniffer dogs evidence is a hearsay evidence. It is a hearsay evidence. It is not direct evidence. Why? Because it is through the master. The master, whatever he will interpret from the dog's evidence, that will be it. Okay. Repo rate, reverse repo rate, that you could not explain properly. Repo is the rate in which the banks take loan from RBI, and reverse repo rate is the rate in which RBI brings money from the banks. Okay, though that is the difference. View on Indian economy, I must say it was appreciable. Okay, so that's it, and I really think you are doing well. Your conceptual clarity is there. Sir also said you have knowledge. Just that, yes, only thing that can stop you from cracking is yourself. If you don't invite trouble by making such answers, that will bring another question altogether. Okay, so avoid that. Go with the confidence, and I believe that you have a fair chance of clearing it this time.
Thank you. Thank you.
Thank you, Suji. You may enjoy.